Welcome to our fifth and penultimate webinar in our anti-money laundering series. My name is Amelia Ramsey and I'm a partner at Duke & George Defence Lawyers. A reminder that these webinars are recorded so that you can return to the Duke & George website to revisit your favourite topics at any time. Next month, Christian Dubner, King's Counsel, will be rejoining us for our final session to tell us about recent and important cases in the area of proceeds of crime and confiscation. But today, continuing on our Victorian focus, we have Eli Fryar joining us. Eli is a commercial barrister practicing in areas of commercial law, proceeds of crime, property and planning, including retail and commercial leasing, as well as equity and trusts. In a past life, Eli was a principal solicitor at the Office of Public Prosecutions, where he had carriage of complex proceeds of crime litigation, as well as quasi-criminal matters. Eli will be today taking us through his hot tips for bringing successful applications under the Victorian Confiscation Act. If you have any questions throughout the presentation or even at the end, please use the Q&A function at any time, and we'll take some time at the end to go through those questions after Eli's presentation. Over to you, Eli.
Thanks very much. I trust that you're all experts now on the framework of the Confiscation Act and the different forfeiture regimes after the last introductory seminar on the Confiscation Act. Today, as Amelia said, I'm going to speak to you about some of the different kinds of applications that can be made under the Confiscation Act, post-restraint, so after a restraining order has been made, but before forfeiture of assets. Now, there are some limited ways in which you can make an application to exclude an interest in property post-forfeiture under the regimes, but given the limited time constraints, I won't be addressing these kinds of applications today. I'll be focusing on the pre-forfeiture kinds of applications. Now, there are three main applications you can make under the Confiscation Act. The first being the exclusion application, also applications for an extension of time to file an exclusion application, as well as applications for a stay of an exclusion application pending the finalisation of the related criminal matter. These are the most commonly made applications. Well, I think the exclusion application in particular, and it's also the most litigated application. Now, an application for an order excluding a person's interest in property from the operation from a restraining order can be made by anyone who has an interest in the restrained property, except in the case of serious drug offence restraining orders, where the accused is unable to bring such an application. They're barred from that procedure. So that's something to look out for when you're bringing these kinds of applications, and something that sometimes catches practitioners out. Now, you will no doubt remember from the last seminar that the definition of interest is wide. It includes legal interest, equitable interests, as well as someone who has a right, power, privilege over or in connection with property. So it is of wide import, meaning that many people can bring exclusion applications. Now, an exclusion application must be made in the prescribed form, which can be found in the relevant court rules, which we discussed, I understand, last seminar. Now, an interest in property which is restrained for the purpose of automatic forfeiture and which is not subject to an exclusion application is automatically forfeited to the minister 60 days after conviction. So that's important to note. There's two further things to note. The meaning of conviction is the earlier of the date on which the accused is arraigned and pleads guilty to a Schedule 2 offence under the Confiscation Act, or on the date on which the accused is found guilty. It's not the date of sentence. Again, something to watch out for and something which can trip up practitioners. The second point to note is that the general rule is that a court does not have jurisdiction to hear and determine an exclusion application under the pre-forfeiture regime once the property has been automatically forfeited to the minister, because at that juncture, the property automatically and irreversibly vests in the minister, and the restraining order is no longer in existence. So exclusion applications should be made before automatic forfeiture occurs. Now, the time limit to bring exclusion applications is generally 30 days from service of the restraining order for charge conviction-based restraining orders, also for serious drug offence restraining orders and civil forfeiture restraining orders. It's 60 days for explained wealth restraining orders. Timing is important, as I'm sure you've heard a number of times mentioned throughout these seminars. So as soon as your client provides you with a copy of the restraining order, see which kind of restraining order it is and prepare your application. But as a general rule, if you work towards filing an application within 30 days, it's generally a safe limit to work towards. The time for filing exclusion applications can be extended under Section 20 Capital 1B of the Confiscation Act if you don't file within time. Now, Section 21 Capital B of the Confiscation Act provides the following. Subject to subsection 1C, the court may extend the period within which an application may be made, whether or not that period has expired, if it is in the interests of justice to do so. The court may not extend the period within which an application may be made in respect to property that has been forfeited under the Act. So it's a wide test of whether or not it's in the interest of justice to extend time. Now, an application for an extension of time should be made within the prescribed form and also accompanied by an affidavit in support deposed to by your client, the applicant. That's more preferable than a solicitor affidavit, and it should set out all of the periods of delay in bringing the application and the causes for those periods of delay. Now, you can combine both an extension of time application together with an exclusion application and make it one document. So that way, if time's extended, you don't need to then go and file a separate application for an exclusion order. If you're out of time, deal with them both together in the same exclusion application. Now, in determining whether or not it's in the interest of justice to extend time, the court will consider the factors enunciated in the case of Finn, F-I-N-N, and the Director of Public Prosecutions, square brackets, 2011, VSC 234. Now, those factors were enunciated at paragraph 14, and the court will consider, firstly, the period of delay, explanations for the delay. So it's really important that all delay is explained and the reasons advanced to justify the delay being excused, whether there is any injustice or prejudice to any applicant for exclusion if the period is not extended, and also if there's any irremediable prejudice to the director if the period is extended, whether the prospects of success of the exclusion application is realistic and not fanciful, the history of the proceedings under the Act and of the prosecution charges faced by the defendant, and the statutory context of orders providing exclusion from restraining orders. So familiarise yourself with those Finn factors if you're faced with an extension of time application. They're very important. Now, let's assume for the moment that your client has filed an exclusion application within time. What do you do next? Well, you have two options, depending on what kind of restraining order it is that you're dealing with. The first option is entering into timetabling orders with the director, either by consent or on the first return of the exclusion application. And those timetabling orders will provide for your client to file their affidavit material in support of the exclusion application. That's option one if your client wants to prosecute and progress the exclusion application swiftly for whatever reason. Now, the second option is for charge and conviction-based restraining orders, your client can apply under Section 20, subsection 7, as of right, to stay the exclusion application pending the finalisation of the criminal charges against them. And of course, the benefit in doing that is because if your client, your charges are resolved, withdrawn, or otherwise dismissed later down the track, then your client's going to save themselves the expenses of putting on their confiscation proceeding affidavit evidence and going to that expense, only then to find out that the charges aren't progressing or have been dismissed or withdrawn. Now, similar provisions for a stay do exist in relation to unexplained wealth restraining orders under Section 40, capital R, subsection 11. However, the grant of those kinds of stays are not as of right. There's an extra hurdle that your client has to overcome, and that is to satisfy the court that not ordering a stay of the hearing would prejudice the fairness of the hearing of the charge. So that's something to consider if you're dealing with an unexplained wealth restraining order, Section 4R, subsection 11. Civil forfeiture restraining orders can also be stayed under Section 36U, subsection 10, but I won't go into that section just at the moment. Now, moving to the exclusion test. So you've diligently filed your client's exclusion application within time, or otherwise you've had time extended by the court. Alternatively, your client is instructing you to prosecute the exclusion application for whatever reason before the charges are finally determined and heard. What do you do next? Well, the first step is to identify the relevant exclusion test, which your client bears the burden of satisfying on the balance of probabilities. As I think, which would have been mentioned in the last seminar, the exclusion applicant bears the burden of proving those criteria on the balance of probabilities. It's a reverse onus which applies. Now, we know that the first threshold issue is interest, and you need to satisfy that your client has an interest in the property, and of course go back to Section 3 to determine what is an interest: equitable, legal, right, power, or privilege. You then need to identify and prove every one of the exclusion criteria relevant to the statutory test. It's not enough just to pick and choose the ones that are convenient to your client. You need to meticulously go through each of the exclusion criteria. I find the best way to do that is in the affidavit itself, identify the section that relates to your client, and then set out every one of the exclusion criteria with the evidence underneath each of those criteria. So the director and the court can see that you have satisfied or attempting to satisfy every one of those criteria. The exclusion test applicable to Schedule 1 offences, which are defined as not Schedule 2 offences, and just pausing there for a moment, I think the best way to become familiar with what is a Schedule 1 offence, what is a Schedule 2 offence, is going to the relevant schedule at the back of the Confiscation Act and familiarising yourself with those different offences. But the exclusion test for Schedule 1 offences is Section 21. The exclusion test for Schedule 2 offences is set out in Section 2. Now, the exclusion test for serious drug offence restraining orders is in 22 capital A. The exclusion test for civil forfeiture restraining orders is in 36 capital B. There's also the exclusion test for unexplained wealth restraining orders in Section 40 capital S. So there's a number of different provisions to get your head around, but just turning to those provisions and working through them, they're all set out nice and neatly. I'm going to turn now in detail to the exclusion test in Section 22, i.e. charge or conviction-based restraining orders for Schedule 2 offences, and deal with that exclusion criteria. That's the test that I see most applicable and most litigated in this space. Schedule 2 offences obviously include charges such as trafficking in commercial quantities of drugs of dependence, trafficking in automatic forfeiture quantities of drugs of dependence. If you don't know what an automatic forfeiture quantity is, have a look at Part 3 of Schedule 11 of the Drugs Act. That sets out the definition there. But generally, an automatic forfeiture quantity is 30 grams of the drug of dependence. Schedule 2 offences also include theft and obtained financial advantage by deception charges, where one offence is charged, the value of the theft or the financial advantage obtained is greater than $50,000, or if it's one or more offences, greater than $75,000. So Schedule 2 offences really capture a lot of the kind of offending where you see restraining orders made for the purpose of automatic forfeiture to the state. Now, this test that I see come up time and time again is broken really down into 2 parts. The first part is the exclusion test for an accused person who's been charged with the offence. They need to satisfy the criteria under 22 subsection 1a. And then the second exclusion test is set out at section 22 1b of the Confiscation Act. And that is for exclusion applications made by persons other than the accused. So, for instance, third parties such as the wife or the family member of the accused who has contributed to the purchase of restrained property, but who are not the legal title holder of that property, and maybe they're alleging an equitable interest by virtue of a resulting implied or constructive trust. Now, in order for a court to make an exclusion order under section 22 1a, that's the accused exclusion test, the court must be satisfied of 4 elements. The first is that the property was lawfully acquired. Secondly, that the property is not tainted property and is not or will not be the subject of a tainted property substitution declaration, and that the property is not derived property. Lastly, the property is not required to satisfy a pecuniary penalty order or a compensation or restitution order. As I said before, it's good to work through each and every one of the criteria and tick them off as you go. Now, at this point, you've identified which test your client must satisfy, and you should, if you have not already, embarked in the process of gathering as much documentary evidence as possible in relation to the acquisition of the restrained property, including things like, if it's a real property, try and get a copy of the conveyancing file, check directions for settlement, loan documentation showing payments towards servicing mortgages, and then also separately bank accounts showing lawful sources of income being used to make those payments to service the mortgages. If your client has been charged with an offence and it looks like there's a chance that they might be incarcerated, then there's more urgency to try and start gathering those documents as soon as you can. As I'm sure you'll all be aware, it's much harder to sort of communicate and get your clients to start that process when they're incarcerated. Now, a useful case in the confiscation space, which explains the meaning of lawfully acquired and is now well established, is the case of Markovsky and the Director of Public Prosecutions. Citation is square brackets 2014 VSC A35. It was held that the exclusion criteria lawfully acquired related to the lawfulness of the source of the funds used to acquire the property and was not limited to the lawfulness of the transaction by which the property was acquired. So that comes back to what I said before. as well as getting the mortgage documents, you really want to get the documents which show the lawful income coming in, which is then applied towards to service the mortgage or pay for the purchase price. Without those documents, you won't get across or past the decision of Markovsky and that exclusion criteria. Now, the second criteria is that the property is not tainted property. The first step is to go to the definition of tainted property in section 3, which I understand that you were taken to in the last seminar, but it's a wide definition which provides includes property that was used or intended to be used in or in connection with the commission of the offence. The phrase "in connection with" is broad. There's the decision of Chalmers and the Queen, 2011, 37 VR 464, where the Victorian Court of Appeal was called upon to interpret those words "used in connection with" the definition of tainted property. And the court held that, firstly, the statutory phrase is of wide scope. The inclusion of the words "in connection with" was plainly intended to extend the scope of the definition of tainted property beyond circumstances where the property could be said to have been used in the commission of the offence. Now, where there is a connection between the use of the property and the commission of the crime in question, it's a question of fact and degree. It's not necessary to establish a substantial connection, and also the nature, extent, and significance of the use of the property in connection with the commission of the crime will be matters which go to the court's discretion whether or not to order forfeiture of the property. So they're sort of the main principles that came out of Chalmers. The Court of Appeal went on to explain very helpfully that the mere fact that an act is done on a particular property will not ordinarily suffice to bring that property within the definition of tainted property. It has to be more of a connection to the use of the property. It can't just be a passive location where an offence occurs. And secondly, that was discussed at paragraph 80. And then secondly, the court went on to say, it is only when the property or some feature or attribute of it has been turned to the advantage by the offender or enlisted to the offender's purpose that it will be possible to say that the property has been used in connection with the commission of the offence. And I think from memory, in the last webinar series, the example that was given was the case of DPP in Basham, where a horrible case where the offender used the roller door of the garage to hang someone, and in that case it was found that the property was used in connection with that offending and therefore tainted property. So the take-home point is that it's a matter of fact and degree. It must be assessed on a case-by-case basis. There's some really clear examples of tainted property. In my view, a crop house is an example of tainted property, and in those circumstances, then your advice would be that an accused person would it would be difficult to overcome, if not impossible to overcome, the exclusion criteria that the property is not tainted. In contrast to that, if it's just a mere passive location where a property, an offence has been carried out, well, in that case, it might not have been used in connection with the offending. If you're unsure whether or not a property is tainted, then you should seek expert advice on the topic. It can get quite blurred in terms of the sliding scale of whether or not a property has been used in connection with the offending. Now, the third criteria which must be satisfied is that the property is not derived property, and derived property is defined in sections 7A and 7B of the Confiscation Act to mean that property used in or in connection with any lawful activity by the accused, or property derived or realised or substantially derived or realised directly or indirectly from any lawful activity by the accused or the applicant for an exclusion order, or property derived or realised or substantially derived or realised directly or indirectly from property of a kind referred to in the previous two subparagraphs. Now, the term unlawful activity is defined in the Act to mean an act or omission that constitutes an offence against a law in force in the Commonwealth, Victoria, or another state or territory or foreign country punishable by a term of imprisonment. So again, property that is derived is again a term of wide import. There have been no decisions really turning on that point that I can take you to. The fourth criteria is that property is not required to satisfy a PPO or a compensation or restitution order. So when you're provided with a restraining order from your client, have a look at the purposes of the restraining order. If there is, the purpose is both compensation and automatic forfeiture, you're going to have some difficulties there unless you turn to Section 23 of the Confiscation Act. Now, if the accused does satisfy the first three elements of the Confiscation Act, but not the fourth element, the applicant can then make an application under Section 23 for a declaration that so much of the property that is not required to satisfy any PPO or an order for restitution or compensation order under the Sentencing Act is excluded. Now, I've rarely seen that section be used in practice, and I think the reason is rarely do accused persons want to agitate their exclusion application prior to the final determination of their charges, and will usually seek to invoke the stay under Section 20, subsection 7 of the Act. Now, that's the accused exclusion test under the Act. The next test is that for third parties, such as innocent parties who are not involved in the offence or the commission of the offence. They must satisfy the exclusion criteria in Section 20, subsection 1, subsection B of the Confiscation Act. Now, if the test is broken down again, if the property your client is seeking to exclude is tainted property, then the criteria in Section 22, 1, B, Roman numeral 1 applies. If the property is not tainted property, then the exclusion criteria in Section 22, subsection 1, subsection B, Roman numeral 2 applies. But what if you're not sure if the property is tainted or not? You'll recall earlier that the factual matrix is not always clear as to whether or not the property is tainted. Sometimes it is if it's a crop house, but what happens if it's not clear? Well, in those circumstances, I would suggest address both the criteria in 22(1)(b), Roman numeral 1 and Roman numeral 2 in your affidavit. Set it all out. Now, the first criteria on the third-party exclusion application test is that the applicant was not in any way involved in the commission of a Schedule 2 offence. Now, that requirement was considered recently by the Court of Appeal in the decision of Hong Yen Lee and DPP 2007, 171 A Crimar 196, or the unreported version is square brackets 2007 VSCA 72. Now, in that case, it involved an offender who cultivated a commercial quantity of cannabis inside a house with which he lived in with his wife. the Court of Appeal held that the exclusion applicant wife could not be said to have been involved in the relevant Schedule 2 offence or trafficking in a commercial quantity of cannabis if she did not know that the offender was cultivating the cannabis for sale, or did not know or believe that there was a real significant chance that the quantity of cannabis was not less than a commercial quantity. However, in view of the evidence as a whole, including the fact that there was a large crop house growing in the property under a sophisticated hydroponic setup, and there were cash bundles throughout the kitchen and other parts of the house, the court concluded, affirming the decision below, that the exclusion applicant had not discharged her onus of proof in the exclusion application. So in that case, it was held that to be involved in the particular offending, the applicant must have either, one, had knowledge of the commission of the offence, the relevant Schedule 2 offence, or was willfully blind to the commission of the relevant Schedule 2 offence. So that is another one to look out for, whether or not your client has been willfully blind in the circumstances. Willful blindness was defined by the court at paragraph 22. Willful blindness includes the actions of a person who deliberately refrains from making inquiries because he or she prefers not to have the result, or who otherwise willfully shuts his or her eyes for fear that they may learn the truth. Now, the next criteria is where the applicant acquired the property before the Schedule 2 offence. They did not do so knowing that the accused would use or intended to use the property in the connection with the commission of the Schedule 2 offence. That criteria has not been judicially considered. Have a look at the objective, the plain meaning of the words. It's more or less self-explanatory. Now, the next criteria is where the applicant acquired the property at the time or after the commission of the Schedule 2 offence. They did so in circumstances such as not to arouse a reasonable suspicion that the property was tainted property or derived property. This criteria has been judicially considered. The matter of McMunn and DPP (2010) Victorian Supreme Court of Appeal 330. In that case, the wife of the offender brought an exclusion application. Now, her husband had been involved throughout their relationship in various dishonesty offences and had been in and out of prison for those offences a number of times. The offender, 3 years after having been released from prison, decided to buy a new family home. The offender told his wife that half of the purchase price was going to be paid from an alleged sale of a software company. The offender husband was subsequently charged with obtaining financial advantage by deception charges. The value of the financial advantage obtained was enough to make it a Schedule 2 offence, and therefore the new family home was restrained. The offender's wife brought an application seeking to exclude her interest in the family home. It was not disputed that the property was tainted property, as it was derived or substantially derived from the commission of the husband's obtaining financial advantage by deception offending. The offender's wife then had to satisfy the exclusion criterion 22B, which required her to, amongst other things, demonstrate that where she had acquired the interest at the time or after the commission or alleged commission of the Schedule 2 offence, she did so without knowing and in circumstances not to arouse a reasonable suspicion that the property was tainted property. The exclusion application was dismissed at the first instance because the court could not be satisfied that the offender's wife had acquired her interest in the restrained property in those particular circumstances. The court went on to say that no person dealing with Mr. McMahon and knowing of his criminal history as at the end of 1994 could sensibly rely on his honesty in relation to any issue or dealing of any financial magnitude, especially if it was financially opportune for him to be dishonest. On appeal, dismissing the appeal, the Court of Appeal went on to hold His Honour, referring to His Honour in the court below, was addressing the question posed by the section, which is whether a reasonable person in circumstances of Mrs. McMahon, knowing what she knew, would have formed a suspicion that the property was tainted property. It is common ground that that is the test to be applied. It pays attention to what the applicant for exclusion actually knew, but asks the question, would a reasonable person in her position have had a suspicion? Mrs. McMahon had to satisfy the judge that that question should be answered in the negative. So I think there's two key takeaways in relation to the decision of McMahon and that exclusion criteria. One is it's an objective test, whether a reasonable person in the circumstances would suspect that the property was tainted property. And it's a suspicion of whether or not the property was tainted, having considered all the circumstances of that particular matter. Now, the fourth exclusion criteria for the third-party exclusion criteria test is that the court must be satisfied on the balance of probabilities that the applicant's interest in the property was not subject to the effective control of the accused on the earlier of the date that the accused was charged with the Schedule 2 offence or the restraining order was made. Now, the effective control is not defined in the Confiscation Act. However, there are two key cases that you need to look to. The first is the Director of Public Prosecution in Ferguson, square brackets 2006 VSC 484, where Justice Kay concluded at paragraph 54, the whole scheme of the Act is to treat the owner of the property, those who in reality exercise a fundamental incident of ownership, namely the practical, effective control of property. Accordingly, the question whether the defendant has effective control of property involves an examination of the actual practical exercise or capacity to exercise by the defendant of rights over the property in question, such as the right to possess, use, sell, mortgage, or make fundamental improvements to and exclude others from possession of the items of property in question. So that's something to keep in mind, that paragraph 54 of Justice Kay's decision in DPP and Ferguson. The other important authority on the point of effective control is the Court of Appeal decision of DPP and 24th Tregenoo, Proprietary Limited, 2011-31, Victorian Reports 439. That matter involved an unsuccessful appeal by the Director of Public Prosecutions in relation to the court's finding below that the offender was not in effective control of the motor vehicle used in his offending. The vehicle was in the offender's primary possession, but was owned legally and beneficially by the offender's father. So although he had possession of that vehicle, the father's company, 24th Tregenoo Proprietary Limited, owned the vehicle. Now, in dismissing the appeal, Associate Justice Hargrave said at paragraph 39, where the relevant interest is one of ownership, substantial control over the right to use or possess property, which remains subject to the owner's right to demand possession and to sell or otherwise dispose of the property for its own benefit is insufficient to constitute effective control of that property. Of course, substantial control of possession may be relevant in the mix of factors when determining whether effective control exists in a particular case, but this is not such a case. So, some good guidance from the courts there about the meaning of effective control that you should be alive to when considering whether or not your client will satisfy the exclusion criteria. Now, the last criteria of the third party exclusion criteria, which I will speak to, is where the applicant acquired the interest from the accused, directly or indirectly, that it was acquired for sufficient consideration. This particular criteria was considered by the Court of Appeal a few years ago in 2022 in the decision of Azizi and Director of Public Prosecutions, Victorian Supreme Court of Appeal 71, so it's square brackets 2022, VSCA 71. Now, in that matter, the Court of Appeal was called upon to consider whether the applicant, who was the innocent wife of the accused, had acquired her interest in the relevant property from the accused directly or indirectly for sufficient consideration. Now, the applicant and the accused were registered as joint proprietors of a property in circumstances where the accused had paid the entire deposit and purchase price. So the accused had paid all funds to acquire the property, but had registered it in both his and her name. Now, the applicant submitted that she had not acquired her interest from the accused, as it was not transferred to her directly by him or indirectly through someone else, i.e. if there was a transfer from the accused to a third party and then a third party to the applicant, it was purchased in both of their names. There was no transfer. The DPP submitted that Section 22A, capital A1C, it was in relation to a serious drug offence restraining order, but the same test applies in the third party tests for conviction and charge-based restraining orders. DPP submitted that it also contemplated a situation where an accused provided the entire purchase price of property, but registered the property or interest in the name of a third party. Now, the appeal was dismissed and the DPP's submissions were accepted. The Court of Appeal held that the term indirectly was sufficient and deliberately broad enough to include, to capture the circumstances where an accused pays for property, but ensures that an interest in the property is vested in a third party, which is what happened here in the wife's circumstances. Now, that's the exclusion criteria. Summing up, my tips for really drilling down on each of the exclusion criteria is setting out headings in your affidavit with your client's instructions in relation to each of them, as much documentary evidence as you can in relation to the lawful acquisition of property, and also taking note of the time limits as well for filing exclusion applications and also automatic forfeiture. Now, I know we're already at 43 minutes. I want to leave time for questions, but I also want to deal with some of the ancillary applications that are made under the Confiscation Act. So as well as exclusion applications under Section 26, it provides that the court, when making a restraining order or at any later time, can make such orders in relation to the property to which the restraining order relates as it considers just. Section 26 subsection 2 provides for the types of people that can make those kinds of applications under the Act, including the DPP, the accused, person who has an interest in the property, prescribed person, or any other person with leave of the court. Now, the most common kind of Section 26 application under the Confiscation Act is where an accused owns restrained property and wishes to sell that property for whatever reason. In those circumstances, the director usually makes standard Section 26 further orders, which will permit the sale of the property, with disbursements to be made at settlement to the registered mortgagee, any caveators who are on title, provided that their interest arose before the restraining order and that they put forward documentary evidence in support of their interest in the property. And then the balance of the proceeds will then be paid to asset confiscation operations, Department of Justice and Community Safety, to be held on trust and restrained until further order of the court. The other kinds of Section 26 further orders I have seen are to permit mortgagee sales of property, to permit an accused to lease or Airbnb a property, or otherwise to permit a payment to be made to a victim in satisfaction of a compensation order which has been awarded to them out of, say, a restrained bank account or something like that. Sometimes also the property is sold and an amount is paid to a victim at settlement. Now, it's under Section 26, it's actually usually a streamlined process with the Office of Public Prosecutions, who will prepare the documents on behalf of the director. So my advice is to, if that's something your client wishes to do, make contact with the OPP early. They'll seek the director's consent, and usually the OPP will take carriage of that process. There's two further kinds of ancillary applications that are made under the Confiscation Act under Section 26. These are provided for under Section 26, subsection 5, subsection c. They are applications for reasonable living expenses and application for reasonable business expenses. Now, the onus is on the applicant in these circumstances to prove on the balance of probabilities, again, that he or she cannot meet reasonable living expenses or reasonable business expenses from unrestrained property, and that the number one, and number two, that the expenses themselves are actually reasonable. In order to do that, application should be filed in the prescribed form, and the affidavit should set out the financial position of the accused and the fact that there's no other unrestrained property that could meet these business and reasonable living expenses. Just generally, I think a court is probably unlikely to permit business expenses or reasonable expenses to be met from restrained property, where a person has unrestrained property available to them, as that coincides with other sections of the Act, such as Section 14, subsection 4, 36H4 and 40 capital C4, which also prevents legal expenses to be paid from restrained property. So they're the kinds of applications that are made pursuant to the Confiscation Act. I hope that has been a good summary. Sort of whiz through that. There's a bunch of exclusion criteria there. If you're ever unsure, please reach out. I'm happy to discuss these kinds of applications with you.
Thank you, Eli. That was fantastic. I have a couple of questions that have come through. One is in relation to forensic accountants and their use in these kinds of matters, and particularly relevant to exclusion applications. The question is, how does one prove the provenance of property without the services of the forensic accountant? And if a forensic accountant is used, usually requires a significant amount of time to conduct an analysis. Can extensions be sought on that basis?
So to answer that question in two parts, I think the source of funds can be proven without the use of a forensic accountant if it's an uncomplicated scenario, say if I have one bank account and all of my wages are paid into that one bank account, and I use that one bank account to purchase one property, then, and that one property is restrained, in those circumstances, it would be fairly straightforward to show, one, my lawful income by getting ATO income statements, two, showing the bank statements where my income is paid to, and three, showing the transfer of the money from my bank account to purchase this property. However, that's not always the case. Sometimes there are complex trust arrangements set up. People purchase cryptocurrency, which involves buying cryptocurrency and then putting them in cryptocurrency wallets and things like that. Sometimes there's a tracing exercise which needs to be undertaken. In those circumstances, yes, forensic accountants are used. They provide their reports. They usually take a long time. However, extensions are usually permitted for that to occur on both sides as well. If the director gets a report, they'll be given time. Similarly, if the exclusion applicant wants a report, they'll also be given time. I think you're on mute, Amelia. I can't hear.
Thanks, Eli. The other question I had was how would a lawyer know if there's a restraining order against their client's property?
Yes, good question, because a lot of time restraining orders are made on an ex parte basis without notice to anybody. Under Section 19 of the Confiscation Act, once a restraining order is obtained, it must be served on anyone with an interest in the property. So if a real property is restrained, it must be served on the registered proprietors, and a copy is also served on any caveators that are on title as well. The other way you could also consider finding out is if your client comes to you, if they have been charged with a Schedule 1 or Schedule 2 offence, they have got significant assets or property that could be restrained, monies in bank accounts and real property, then failing them producing a restraining order to you, you could make inquiries with, one, the prosecuting solicitor, the OPP, or even just a general inquiry at the OPP as well to find out whether or not a restraining order has been made.
Okay. Thanks, Eli. Unless there are any other questions, and I can't see any coming through at this stage, then that wraps up our 5th webinar. So thank you very much for joining us today, Eli, and everybody else attending the webinar. Again, you can watch them online or watch them back again if there were some interesting parts of this you want to revisit. We'll be seeing you all next month. As I said, Christian Jubner will be rejoining us for the final webinar. Wish you all a happy evening and see you soon.
Thank you.